Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day, and we are here with, I suppose, what might be a response video to our very own fellow YouTube legal commentator, Legal Eagle himself, who has filed a lawsuit against the U.S. government for Freedom of Information Act. So we are going to read his lawsuit, and we are going to definitely cover it as it goes because it should be a very interesting lawsuit. He's going to run into very obvious problems, but he is teamed up with a team of lawyers who he says have experience in this area. I can't vouch for these lawyers personally in terms of their experience, but this is not the first time that someone has tried to sue the US government over the Freedom of Information Act and is going to run into these problems. So I'm sure these problems are anticipated, but we're going to cover it and see how it develops every step of the way because why not? So Legal Eagle himself didn't talk about the lawsuit, but that's okay. I have Pacer and I can pull a lawsuit. So let's do that. Let's talk about the actual lawsuit. So this is the lawsuit that was filed. It was filed today, which is amazing because the courts aren't actually open yet. So, because it's pretty early in the morning. So I'm not sure how we actually filed that, but let's look past that issue. I guess you can do new filings in the District Court of Columbia electronically. Nice. And we can see right away that this is from Legal Eagle LLC. So we are suing on behalf of the business enterprise of Legal Eagle. Okay, that's nice. And we are suing the National Security Council, which is the organization within the White House that deals with classified information and secrets within the White House. And we're also suing the Central Intelligence Agency, the Department of Defense, the Department of Justice, the Department of State, and the National Archives and Record Administration, and the Office of the Director of National Intelligence. So we just basically sue the entire intelligence community, pretty much. So that's exciting. And let's see what we've got. Plaintiff Legal Eagle, LLC, brings this action against defendant, National Security Council et al., for violation of the Freedom of Information Act, which is 5 U.S.C. 552, as amended, and declaratory judgment, and the All Writs Act, which we covered a bit yesterday. So yes, there's an act called the Freedom of Information Act, which allows you to get government records that exist within the executive agencies. The White House itself is not really subject to FOIA, so that's an immediate problem, but some of these other organizations are. So okay. We have jurisdiction, we have venue. We're definitely in the right place. Let's learn a little bit about our parties. Plaintiff, Legal Eagle, LLC. Legal Eagle is a business headquartered in the District of Columbia. Legal Eagle runs the Legal Eagle YouTube channel at youtube.com/legaleagle, which is the most popular YouTube channel focused on legal issues, as well as one of the fastest growing educational channels in the world with more than 1 million subscribers, 10 million monthly views, and 100 million total video views. He's done well for himself. No one can deny. And he is creating a space for discussion of legal issues, which is appreciated. Sometimes I wish his legal analysis would be a little bit better, and I wish it would be a little less biased, and I wish that he would be a little bit more open as to his own biases, as I try to be for myself. But most of his legal commentary is workable. Legal Eagle, the organization, is accordingly a representative of the news media within the meaning of some law. I'm sure they are. That's fine. A component of the National Security Council, the defendant, National Security Records Access and Information Security Management Directorate, RAMSID, bears primarily responsibility for classification review of written work submitted to the National Security Council for pre-publication review process. The RAMSID is accordingly an agency within the meaning of the law with substantial independent authority in the exercise of specific functions whose sole function is not to advise and assist the president. RAMSID is in possession or control of records requested by Legal Eagle, which is subject to this action. Okay, so a whole bunch of things that were just said there. So we need to go over some of these details. So if you work for a national security agency, in terms of being an employee or a contractor or anything, you have to sign an agreement. You sign a contract. You sign a non-disclosure agreement, essentially. And this non-disclosure agreement has teeth, because non-disclosure agreement is not just a non-disclosure agreement signed between two parties in which you're going to come into contract violations. No, this is a non-disclosure agreement with teeth, because criminal penalties emerge as a result. And what this says, in broadest possible terms, these agreements, what these say is that you agree to keep secret and confidential anything that was kept secret and confidential during your time. So you have a lifetime ban on sharing any information that you gained from your privileged position, your secret position. So you were in a position of confidence, and you have to keep that information secret indefinitely. Now, if you want to write a book or other memoir or whatever, then that book or whatever has to be cleared in advance for exactly this reason. They have to make sure that the information in there, it does not pertain to any information that is secret, classified, or even confidential within the meaning of the executive agencies, because not everything needs to be classified in order to be secret, or secret is exactly the wrong term, because secret is a classification. Let's go with confidential instead. So yes, there's information that would not be secret within the meaning of a classification scheme that is nevertheless confidential. And as a lawyer, Legal Eagle himself will be well familiar with this concept, because Legal Eagle himself, being a lawyer, knows all about confidentiality. That doesn't mean that it's classified. So Legal Eagle, to the extent that he works as a lawyer for other clients, has to keep information confidential. Is that information classified? No, it's not. It doesn't have a classification designation. I'm just going to assume that he's not working on national security information. So I'm assuming that information coming into his possession is not classified, which raises a whole other scope of problems. But we'll just assume confidential. So he has to keep this information confidential. So yeah, just because something isn't classified doesn't mean that it's not confidential, and also doesn't mean that it can't just be republished. Legal Eagle cannot publish confidential information concerning his clients without their permission or otherwise as authorized by law. He, as a lawyer, is obligated to keep that information secret indefinitely. And in a similar way, a person who's employed by a national security agency, by an intelligence directive, is required to keep confidential information, both that is classified within the meaning of the classification system, and also non-classified information that is confidential. So it doesn't need to be secret or top secret in order to be confidential. So the national security mechanisms have a process to review this. So if you want to publish a book or memoir or other thing, you have to submit what you want to publish to the respective agencies. They get a chance to look it over, and they will come back and say, well, you can't talk about this, can't talk about this, you have to strike this. And it's part of this process. And if you're unhappy with those determinations, you can fight those determinations internally. But this is part of the deal when you accept this on square one. So the very first day that you're employed, as part of your paperwork, you're going to sign an agreement that says all this stuff in advance. So you were told up front about all this. So, it wasn't a surprise. So, they have a chance to review to make sure that you're not going to spill anything that's confidential, secret or otherwise. So that's what they're talking about. And then they say this organization is an agency within the meaning of the law, because the Freedom of Information Act applies only to agencies. As I mentioned, the Freedom of Information Act does not apply to the White House itself. It applies to agencies. So it applies to the CIA and NSA. They have different exemptions. But what Legal Eagle is attempting to claim is that this RAMCID organization is an agency within the meaning of the law and is not solely there to advise the president. Now, whether or not that's true or not, I'm sure will be a potential point of contention. So it may be the case that the government will fight this premise and be like, no, they're not an agency within the meaning of the law. So then we'll have to have a fight about whether or not they're an agency or not. And part of that determination will be based on whether or not their role is solely to serve the President of the United States. If they're an apparatus wholly within the White House that serves to provide information to the President. And if they do things beyond that scope, they might have a exposure that will be relevant under the Freedom of Information Act. But this is going to be a potential point of contention, whether or not this Ramsd thing is an agency within the meaning of the law. So that'll be exciting. Let me just move the live chat real quick. That's better for me. Excellent. Let's press on. Defendant CIA is an agency. Yes, it is. The Pre-Publication Classification Review Board is a CIA component. I'll take your word for it. Department of Defense is an agency. Yes, it is. Department of Defense Agent Office of Pre-Publication are DOJ components. I'll take your word for it. Department of Justice is an agency. Yes, it is. National Security Division and Office of Legal Counsel are DOJ components. I'll take your word for it, because Office of Legal Counsel can also refer to things of other agencies. Most agencies have some equivalent of this, but we're talking about the DOJ specific one. Fine. Department of Defense, Department of State is an agency. Sure, yes, it is. The Defendant National Archives is an agency. Yes. The George W. Bush Presidential Library is a National Archives component. I did not know that. I did not know that the presidential libraries are considered part of the National Archive. That makes sense. I just didn't know that that was true. And it's also a little strange because the information in the presidential library may not be things that are within the archives. So there are rules dealing with presidential records, and presidential records have to be maintained and kept. So presidential papers are within the meaning of the archives, but archives might have things beyond the scope. So the idea that the National Archives are administering things that may not necessarily have to be maintained by law is pretty interesting. So I did not know that. Okay, interesting detail. Presidential libraries are apparently governed by the National Archives. All right. Defendant Office and Director of National Intelligence is an agency within the meaning of the law and its possession roles. I'll take your word for it. All right, so now we get into the pre-publication review. So now Legal Eagle is going to tell you what I told you about 5 minutes ago, because I got to it first. All right, any person who is in possession of a security clearance to access classified national security information must sign a non-disclosure agreement, agreeing to, among other things, to submit any document related to his or her national security employment for pre-publication review before disclosing them to any third party not authorized by the United States government to access them. So yes, if you want to publish things to the general public at large, we get to look at it first. The two most common NDAs for classified information are SF 312, governing all classified information, and Form 4414, governing a subset known as sensitive compartmentalized information. Exciting. An author generally submits his document to the pre-publication review office of the agency which sponsors or sponsored the clearance. This may not always be the agency where the author works. Yeah, security clearances are a really weird thing. And they're really weird in particular because they're agency by agency specific. And it's really weird because you have to be clear. It's at least a little weird to me, right? There's no like global classification or global security level, unless you're like the president of the United States or basically authorized by him. The president of the United States can access classified information everywhere. It's one of his perks. And there are other people like the DNI who can probably access classified information everywhere. So if you're of a high enough tier, you get access to all the classified information. It's kind of nice. But if you're not of the highest of highest tiers, then you have to be specifically cleared by each agency, and you have to be given a clearance by each agency. And those clearances may be different. And so to get around this massive inconvenience, because the whole thing is a little strange, you've been cleared, you've been given, the whole thing is a little weird, right? You've been given top secret security clearance, say by the CIA. And now you want to work for the NSA, and now they're going to look at you again. It's like, didn't we just do this? So to get around this problem, the agencies share with each other without them being formally transferred. So you may be you may be formally employed by the CIA and working for the NSA or whatever. And so, yeah, you would submit your request to the people who gave you the security information because they're the ones that are binding you, even though you got information from other places. So yes, if on your CIA travels you gain information from the NSA or whomever else, then the person you'd ask is the CIA, and the CIA might in turn then ask the NSA, which is also why these pre-publication reviews take forever, and also because everyone is very jealous of their turf. So it's a massive turf war because it's always been a turf war in the intelligence agencies. So yeah, you work for the NSA and you gain some information from the CIA and also the FBI because they have an intelligence component, and also geospatial, which is my personal favorite intelligence agency because they don't get any love, but they're my personal favorite, the geospatial people, because they deal with the reconnaissance satellites. They're my personal favorite. So you have obtained information from all these people during your travels, and now you want to write a book. So yes, you would submit it to the NSA, who then might ask the CIA, geospatial, FBI what they think, and of course it's a turf war, and everyone has to have an opinion, and so it takes forever and a day. But then again, you did agree to this when you signed up, so what do you want? Yeah, so this the person who gave you clearance may or may not be the place where you wind up working. Yeah. Each agency generally has a specific office for conducting the pre-publication review, although pre-publication review is often not solely the responsibility of the office, which makes total sense. The office coordinates it. So yes, you submit it to the office for pre-publication review, and then they go forth and they start to ask all the people that they need to ask, and all those people are very jealous of their turf, and it takes forever, and yeah. For example, the RAMSID is responsible for conducting the pre-publication review for National Security Council personnel. Sure. So the National Security Council is a thing within the White House, which makes me slightly doubtful that RAMSID is an agency within the meaning of the law. So Legal said it is a predicate. They're an agency. I'm slightly doubtful because I don't think the National Security Council is an agency, and therefore an arm of the NSC probably is not an agency either. So I'm a little bit doubtful of that claim. The Pre-Publication Classified Review Board, formerly known as the Publication Review Board, is responsible for conducting pre-publication review for CIA. The Defense Office of Pre-Publication is responsible for conducting pre-publication of DOD. The Office of Information Programs and Services is responsible for conducting pre-publication review for state. The Information Management Division is responsible for conducting pre-publication review for the Director of National Intelligence. Each agency processes pre-publication review requests differently according to agency-specific rules. Yes, they do. Because again, this is a massive turf war. This is in part why 9/11 happened, at least in part, because the agencies are very, very protective of their turf, and they don't like to share with the other children. They have a culture of secrecy, including from each other. And so, yes, they have, and even after 9/11, when we tried to integrate them and created Homeland Security to try to integrate them, even after that, they are still very, very jealous of their turf. They like their turf very much, and they would like everyone else to get off their lawn. So yes, each agency has its own rules, which can be faithfully described as Kafkaesque in many circumstances, because again, they're jealous of their turf. So yeah, there's no standardized process which applies to all the agencies, although most agencies possess several common characteristics. That is extremely true. Yes, they're all vaguely dealing with. I mean, they're all kind of dealing with different things, but under very broadly the same categorizations. Like there's a common classification schema. Each one of them is applying them individually because of course they are. So there's no universal classification because each agency gets to classify stuff on its own, and they get to classify it differently, and they get to have different security clearances. And so the same document can be reviewed by multiple different agencies and given different security clearances, even though they're applying the same rule, because there's no universal schema for these things, because the children don't like sharing with each other. Yeah. One characteristic shared by several agencies is the idea that an agency can deny an author permission to publish both classified and unclassified information in different circumstances. For example, several agencies reserve the right to deny a current employer or contractor permission to publish unclassified information, which could interfere with the function, while stating that the works of former employees may only be reviewed for classifying information. Other agencies do not draw a clear line between the two and suggest they can deny an author to publish certain types of unclassified information, such as controlled unclassified information and information which would adversely affect foreign relations even if the author is a former employee. Yeah, okay. So, as I was stating a little bit earlier, the idea of something being classified, right? If we talk about things being classified, there's actual statutes and actual rules on that. There's an actual thing that tells you how to classify and tells you when something is secret and top secret and when that information becomes public and when it doesn't. And all kinds of rules for declassification and all kinds of stuff, right? So yes, so we have the classification, but confidential isn't necessarily the same thing as classified. And what they're pointing out here is that these agencies are using this review as a chance to also look at things that are confidential, if not classified, and denying you the ability to publish things that are confidential, if not classified. Now, can they do that as part of that review or not? I don't know. Very interesting question or not. You probably don't have the right to publish it in any event, but whether or not they can review it as part of their process, it's a little bit open. The reason it's a little bit open is because an employee who never signed this non-disclosure agreement, right? So there might be employees within the NSA who do not have NDAs because they're not classified. So there's probably are non-classified components to even like the NSA and CIA. So it might be possible to work for the CIA and NSA or a intelligence agency without having one of these things, because you would never come into possession of classified information. I mean, the CIA and NSA and FBI and everyone else for that matter, who's an intelligence agency, does generate non-classified information. So it might be possible for you to be an employee of one of these agencies and never touch classified information. And so you would never sign one of these NDAs. And so if you wanted to publish a book, I'm not sure why anyone wants to read it, but if you wanted to publish a book, you wouldn't have to go through the pre-clearance because you never had a security clearance, even though you worked for the CIA. So what he's trying to point out here is that if you were the kind of person who never signed one of these things, you'd be able to publish this material without being pre-cleared. So should a person who signed a secrecy agreement should they be able to review, and should they be denying publication of stuff that's confidential, if not secret? But then again, as I was trying to point out a little bit earlier, Devin, Legal Eagle himself, is very familiar with the idea of confidential, but not classified, because he deals with them all the time, because he's a lawyer. So he knows very well the idea of, yeah, maybe you shouldn't be able to pre-review it, but it doesn't mean that you can't publish it. So, should they be able to review this and should they be able to deny it as part of the process? I don't know, but they are. So, okay. Another characteristic shared by several agencies is the practice of interagency consultation when conducting pre-publication review of a document which includes information pertaining to more one agency. Yes, that was what I was saying earlier, although I wouldn't really call it a process of interagency consultation. That's kind of a technical description, but it's more similar to sisters fighting than anything else. When it's interesting because when you talk about intelligence agencies, if you're one intelligence agency and you talk about other intelligence agencies, you normally use the descriptor of sister. You call them a sister intelligence agency. And, when it comes to sharing and things like that, sometimes they do behave a little bit like little girls. So, yeah, sister, yeah. For example, if a former CIA employee author submits a manuscript to the CIA, which describes her work on the CIA DOD Choice Force, They would consult the other people and coordinate the review. Yes, they would. That's a very charitable way of describing what happens. The government asserts that Ramsden does not have any formal rules for governing its pre-publication process. Probably true. Former National Security Advisor Bolton signed both the SF 312 and Form 4414 as condition of his employment. I'm sure he did. On the 30th of December 2019, Bolton submitted a copy of the manuscript for his book, The Room Where It Happened, to Ramsden for pre-publication. On January the 23rd, Ramsden informed Bolton that the manuscript appears to contain a significant amount of classified information. The government believes that all or part of the manuscript was distributed to multiple individuals as early as 26th of January. On the 7th of February, Ramsden informed Bolton the manuscript contained numerous instances of classified information. Between February the 7th and the 27th of April, Bolton and Ramsden engaged in an iterative process of reviewing, editing, and submission, which seems pretty fast to me. You know, I don't have any personal experience in this domain, but this seems like a pretty fast turnaround. You know, the initial manuscript was submitted in, what was it, November, and by February, so 2 months later, they've taken their initial review, and there seems to be, there's a whole bunch of things. And then over the next 2 months, or 3 months, they start to engage in negotiations and discussions over it, which seems like a pretty responsible process. So this doesn't strike me as like inordinate like levels of review, particularly at a time, lest we forget, the government had other things on its mind. For example, the whole COVID situation and civil unrest and a whole bunch of other stuff. So, you know, the intelligence, the apparatuses were not at their best because they too have been impacted like everyone else. And so they've seemed to be operating in a timeline that seems to be consistent with their obligations as far as I can tell. On April 27th, the Ramsden senior director, Elian Knight, completed her pre-publication review and informed the NSC Office of Legal Advisor, which she had corresponded with at various points. Yeah, she's talking with the lawyers, which is something you would do. Of course she's talking to the lawyers. You say this like it's a bad thing. She was in the judgment the manuscript draft did not contain classified information. Great. So that person says, I'm good. Fantastic. On 2nd of May 2020, NSC Senior Director of Intelligence commenced an additional review. So we have one person's opinion, but now a senior director wants to offer an opinion. On the 9th of June 2020, Elias completed his additional review and concluded that it still contains classified information. So one person said, this looks okay. Another person says, I want to take another look at it and think, no, there's still a problem. Again, these timelines seem reasonable to my mind. On 10th of June, Bolton informed the NSC that the book has now been printed, bound, and shipped to distributors. He's jumped the gun. So Bolton seems to be acting irresponsibly. You know, and it seems the government is acting responsibly. You know? Maybe the government took too long. And maybe submitting an initial draft in November and being able to be expected to be done by June is a more reasonable expectation. But to my mind, when I read these dates, it doesn't strike me as, this is obviously a real, problem. You know, he submitted it. They took an initial review over it. They engaged in some discussions. Some junior person took a look at it, said, I'm good. And then some more senior person said, well, I want to take another look and I still have problems. These timelines seem like reasonable timelines. When we're talking about classified information and review of those information and making sure the classifications are good and trying to look at all that, and we're dealing with interagency stuff, and we're dealing with the sister agencies squabbling amongst themselves. Like, this 6-month time frame seems pretty reasonable to my mind. And Bolton says, I'm just going to go publish it and distribute it. That seems very irresponsible, if not illegal. You know? So it seems like the government is behaving responsibly. It seems like Bolton is behaving irresponsibly. People who watch this channel know that I'm not afraid to give the government crap if I think the government is crap. So it shouldn't be misunderstood as me like just being a rah for the government. I give the government plenty of crap. I just try to look at everything fact specific, like a lawyer. I just try to look at the case in front of me and try to figure out who's in the right and who's in the wrong in any given situation. And to my mind, on these facts, it seems like Bolton is in the wrong and the government's in the right. There will probably be another time, and probably soon, when the government will be in the wrong, but it doesn't seem like today. On the 16th of June 2020, DOJ filed a lawsuit against Bolton alleging he breached his NDA by publishing the book before pre-publication review was complete. Sounds like it. On the 17th of June, DOJ filed a motion for a TRO, which is a perfectly reasonable thing to do. On the 20th of June, Judge Royce Lampworth denied the motion for a TRO, but opined the court is persuaded that defendant Bolton likely jeopardized national security by disclosing classified information in violation of non-disclosure agreements. Yeah, so the judge denied the TRO, but said it looks like there's a problem here. So Bolton might be on the hook, man. Bolton might be on the hook for violating these NDAs and violating his obligations under the statute. So a criminal prosecution of Bolton may be in the works here, because it looks like Bolton violated several provisions of law in publishing this book and not going through the process. And the process didn't seem unduly onerous or unduly long. It seemed reasonable. It seemed like it was going ahead judiciously, and he went forward. So yeah, he might be liable, and there might be some criminal exposure. So DOJ might be filing a criminal lawsuit against Bolton any day now. Who knows? That'll be fun. All right, so now that we've learned a little bit about the history there, let's learn about Legal Eagle. The Legal Eagle YouTube channel features a recurring segment entitled Real Law Review, in which the host explains the legal issues behind the major stories in the news, such as discussions about executive power, privilege, impeachment, and related issues, for a general audience. Recognizing the legal implications of the then burgeoning dispute between Bolton and the White House over the publication of the book, Legal Eagle submitted a series of FOIA requests in February 2020, with the intention of obtaining, or at least forcing the government to properly process under FOIA, information which the government was attempting to prevent Bolton from publishing through pre-publication review, as well as information about the review process being applied to the manuscript. Okay. Legal Eagle reasonably anticipated there was a significant likelihood that the RAMCID would seek to prohibit the pre-publication of unclassified information or improperly retroactively classified to prevent disclosure, which is another wonderful thing that the classification agencies get to do. So yeah, they get to change classification status, and they get to change it retroactively. So it's like, oh, this stuff is unclassified, but now it's classified. So yeah, they get to change their mind on classification schemas. And especially if someone reviews it's like, oh, that should be a secret. So, it's not like classification is perfect in the first instance. So someone might have screwed up, and then maybe they should have classified something that wasn't classified. And now's a chance to do that. So yes, it's totally possible that as part of the review process, someone will say, okay, now let's classify information. Which is also, incidentally, why you're required to give the government a chance to look at it, to make sure that anything you're about to make super public in a open book, right, is really public. So before we make it super public, let's make sure. Many of Legal Eagle's requests were submitted to agencies within RAMCID would have necessarily consulted, such as these other organizations, probably. On the 3rd of March 2020, Legal Eagle successfully submitted 4 requests, one of which is not issue at this case, directly to RAMCID after making multiple attempts, including one instance in which the United States Postal Service delivered a certified mail package addressed to Knight and RAMCID at the White House, and an unknown person marked it RTS/IA for return to sender insufficient address 3 days later and returned to the Legal Eagle's undersigned counsel in an apparent attempt to delay or prevent its delivery. Yeah, so so we tried to mark it, but we didn't provide enough address information. On the 26th of May, Legal Eagle filed new requests to several agencies to obtain this, and Legal Eagle has received no records as of this writing, which is, a month ago. So they are probably within their windows to reply. So we're being very, or just over the windows to reply. So we are really trying to get this thing. All right, causes of action. Legal Eagle repeats and realleges the allegations contained in all sets forth above. I love how Legal Eagle just keeps referring to himself essentially in the third person. He's created an organization called Legal Eagle LLC. So, Legal Eagle himself, Mr. Eagle himself, is the one filing this lawsuit. Not Devin. No, Legal Eagle. Okay. On the 3rd of March 2020, Legal Eagle submitted to Ramsden a FOIA request for all the information from the first manuscript for the forthcoming book, The Room Where It Happened. Submitted to your office for the formal National Security Advisor, John Bolton, the government had prohibited or is attempting to prohibit Bolton from publishing. Legal Eagle additionally discussed 11 potential scenarios to illustrate how Ramsden should determine which information would be responsive, since the purpose of this request is to learn which parts of the manuscript the government wants to censor, not to get a free copy of the book. Legal Eagle requested expedited processing and a public interest fee waiver, so he doesn't even want to pay for the FOIA request. Nice. Citing extensive public interest in pre-publication review in General Enno's supplied book. He still had to pay the $400 to file this lawsuit, though, so he was willing to fork up the $400 to file this lawsuit, but he wasn't willing to fork up the money for the FOIA request because it was in the public interest. Legal Eagle also stated, in anticipation of your potential argument that your office is not subject to FOIA. Ooh. We are familiar with the relevant case law on this matter, and we do not dispute that the National Security Council as a whole is not an agency for the purpose of FOIA because it lacks independent decision-making authority, which is what I said. Yeah. However, the Access Management Director does possess independent decision-making authority and does not exist solely to advise the process, and as such, your office is an agency for the purpose of FOIA, more like the Office of Management and Budget and Council on Environmental Quality than like the rest of the NSC. Okay, yeah, I don't know about that, and that's going to be a legal point of contention. And I think the government probably has the better end of that argument. So, Legal Eagle admits, as he must, because it's pretty clear, the NSC as such is not an agency, because the NSC as such is basically a mechanism to provide is essentially in practice the heads of the respective intelligence agencies, although the president can reform at any time. So who's on the NSC at any given time can change depending on who the president is. But in practice, it is the director of national intelligence, the head of the CIA, the usually the Secretary of State is part of that. There and other heads of the head of the Joint Chiefs is there, and other people that are in the senior echelons of intelligence. And so this group exists to provide all the intelligence information to the president that he needs to do his stuff. So that's the National Security Council at large, basically. And you can add and subtract other people. The Attorney General is usually a member. So those are some of your people who might be a part of the NSC. So Legal Eagle says the NSC as such is not an agency within the meaning of the law, which it's not. And because they don't have independent decision-making authority. But he says that this, Ramsden is an agency because they do have an independent making authority. Now, I think it's a bit contentious as a legal conclusion because the ransom, I don't know how to pronounce this, the ransom is a organization within the NSC that does the security clearance stuff for the NSC. So it is a entity that exists in service to the NSC. So even though they have some independent decision-making authority, their independent decision-making authority is in service to the NSC, which itself is not an independent agency. So I think it is legally dubious as a proposition that a non-agency can, through its machinations, create an agency that would then be subject to FOIA. That doesn't strike me as something that makes sense, right? In the same way that like an agency couldn't get out of FOIA by trying to create a non-agency. So the CIA is an agency. They can't then turn around and say some subcomponent of the CIA, such as our internal review mechanism. Well, our internal review mechanism isn't an agency. And legal would say that's nonsense, and it is nonsense, right? The CIA creates an entity within itself and says, well, that aspect is not an agency. And it's like, well, yes, it is. It's in service to you, the agency. So they gain the agency status from the thing that created them, right? So in the same way, I would view it as absurd for the CIA to say some subcomponent of the CIA is not an agency, even though the CIA as a whole is an agency. I think it flows logically that the NSC, a non-agency, when it creates a subcomponent of itself, that subcomponent doesn't become an agency, even if it has some independent judgment, because it's in service to a non-entity. It would be like saying the NSC itself is an agency, because the NSC itself is something basically created by the president out of thin air, essentially, and it can be anyone he wants. So when the White House, as such, is not an agency, the president, as such, is not an agency. So this logic that legal seems to be trying to use would seem to apply to the NSC. When the president creates the NSC, he's created something with some independent rulemaking authority. And so that becomes an agency. And the courts have already said, no, it isn't. It's not an agency. And so the NSC itself has created a subcomponent. And now that becomes an agency? I am doubtful. So I am sure that Legal Eagle and his lawyers are super, super familiar with the case law and all. But the Office of Management Budget and Council on Environmental Quality, yes, those are independent. But the idea that a subcomponent of the NSC is independent, I am legally dubious on that one. I think the government has the better end of that likely legal proposition. On the 9th of March 2020, the Ramsden acknowledged receipt of the request and refused to process it, stating as an organization in the Executive Office of the President that advises and assists the President and the NSC, they're not subject to the FOIA, which seems like a reasonable legal position. If Legal Eagle, Devin himself over here, wants to try to fight them on that, good luck on that and all. But I think that they probably have the better end of that legal argument. So I would not expect Legal Eagle to win that fight, but a court might look at it differently as it becomes more developed. I guess we'll see. Legal Eagle has obtained the legal right under FOIA to obtain the relief he seeks, and there's no legal basis to deny Ramsden of the right. All right, Legal Eagle repeats and realleges the allegations contained in all the paragraphs set forth above. Legal Eagle demonstrates that there's an urgent need of a requester primarily engaged in dissemination information to inform the public about an actual or alleged federal government activity, the pre-publication of the manuscript. By refusing to process the request, the Ramsden has necessarily denied its request for expedited processes. Yes. Well, I don't know if that's necessarily true, actually. Legal says by denying the request, we denied the request for expedited processing. I'm not so sure. We gave you expedited processing. We just said no. So I'm not sure that's true. We did give you expedited processing. We said no very quickly. Legal has a right under FOIA to have this request processed expeditiously. There's no basis for denial of the right. Yeah. I think they did process it expeditiously. They just said no very fast. Legal Eagle repeats the allegations. On the 3rd of March 2020, Legal Eagle submits to Ramsden a FOIA request for various types of records relating to the pre-publication review, including records discussing pre-publication review of any manuscript written by Bolton, records including Bolton's names, his lawyer's name or title of his book, and correspondence exchange with Bolton, his agencies, or his publisher. Very exciting. Legal Eagle requests expedite processing of the request in the public interest, citing extensive public interest in the pre-publication review process in general and as applied to Bolton's book. Legal Eagle stated also, yeah, we covered that argument earlier, so we don't have to cover it again. We're a different cause of action, so we're going to repeat it, but we already covered that, so we know what it says. Legal Eagle repeats these allegations. Legal Eagle demonstrates that there's urgent need of the requester primarily engaged in disseminating to inform the public about actual or alleged federal government activity. By refusing this process, Ramsden necessarily denies this request. $5 from Q Squared. Thank you very much for the super chat. It's appreciated. The real purpose of this lawsuit to get Kurt to say Legal Eagle umpteen thousand times. A massive rickroll is you. Love what you do, Kurt. No problem. You think maybe I should stop using the phrase Legal Eagle and just call him LE or something to not give him branding? I don't know. That seems, I'll think about it. But thank you for the super chat. It is super, super appreciated as always. Thank you. Incidentally, if you do like this content and you've not already done so, if you'd please be so kind as to give this stream a like, it would help immensely. And as always, we do appreciate your super chats. And if you'd like to become a member of the channel, theoretically on your screen somewhere, there should be a join button. And if you hit that button for 99 cents a month, you too can become an uncivilian. And your support, as always, is appreciated. Thank you. Legal Eagle posted a video about the lawsuit. How do you think I learned about it? Legal Eagle repeats and realleges the allegations. On 18th of February 2020, Legal Eagle submitted to the CIA a FOIA request for various types of records relating to the pre-publication request, including records discussing pre-publication review of any manuscript written by Bolton, records including Bolton's name or title of his book, and portions of the manuscript that were provided for the CIA to pre-publication review. Okay. Legal Eagle requested expedited processing. On the 24th of February 2020, CIA acknowledged receipt of this request and assigned it a number. CIA denied Legal Eagle's request for expedited processing and did not adjudicate its request for a waiver. On the 20th of May 2020, Legal Eagle submitted to CIA a FOIA for all records responsive to the request, which were created since the cutoff date of the request, a second request. We assigned a new number. We denied expedited processing, and we did not adjudicate. They've not issued a final response to these requests. As 20 working days have elapsed without substantial determination, Legal Eagle has exhausted his administrative remedies. I'm not familiar enough to know with FOIA if he's exhausted his administrative remedies or not. But yeah, we are going immediately to court. So, okay. Legal Eagle has a right under FOIA to the information it seeks. There's no legal basis for denial of CIA of the right. We'll get into the legal basis for the CIA and everyone else to deny at the end of the stream, because we're going to cover the Freedom of Information Act and some of its exceptions at the end of this. So we're going to cover all the problems that Legal Eagle hasn't told you about. You know, there's this, well, this is, maybe there's some clickbait here. The nine weird tricks the CIA has to deny your FOIA. Number 3 will shock you. Yeah. Legal Eagle repeats these allegations. Legal Eagle demonstrates there's urgent need to inform the public. CIA has denied the request. Legal Eagle has a right. We'll get to that in a minute. Legal Eagle repeats these allegations. On the 18th of February, LE, I guess we'll just call him LE from now on, LE submitted to OSD JS a DOD-specific version of the request. LE requested expedited processing of the request and public interest. That means he can start calling me UL. So yeah, we can start referring to each other in, I like this actually. So yeah, we could talk about each other in shorthand. So we'll talk about the legal channels that are UL, LE, NB, VF, CR, HL. Yeah, we can start just referring to each other by 2-letter acronyms. This is great. Yeah, I love this. This is good. So yeah, we'll just start referring to each other legal channels by 2-letter acronyms. All legal channels that are worth mentioning have 2-letter acronyms. LE requested expedited processing of this request. I also want to be noted for the record that I do respect LE enough not to dox him. So, I did redact that out. So just, did try to be thoughtful there a little bit. Oh yeah. LM. That's right. We can't forget LM. Sorry. Can't forget. We can't forget LM with LF. That's right. LM. All that good stuff. No, someone said no acronyms. Someone in chat says no acronyms. Man, geez, you are in the wrong case if you don't want acronyms, because we are about to do alphabet soup for days. We've got CIA, NSA, OSD, JS. We got acronyms out the wazoo, man. Nothing but acronyms and national initialisms all day long. That's what this is. Yeah. Ellie repeats and realleges the allegations contained in the paragraph set. Ellie demonstrates there's an urgent need of requester primarily engaged in dissemination to inform the public about alleged FG activity. OSD and JS denied LE's requests for expedited processing, both for the bulletin notes. LE has a legal right to this. LE repeats the allegations. On the 18th of February 2020, LE submitted to NSD a DOJ specific of the request. LE requested expedited processing of the request and public interest fee waiver, citing extensive public interest and pre-publication review as general as applied to the book. On the 3rd of March 2020, NSD acknowledged receipt of this request and assigned it a request number. NSD granted LE's request for expedited processing and did not adjudicate its request. On the 26th of May 2020, LE submitted to NSD a DOJ-specific version of the request. As of this date, NSD has not acknowledged it. It readily anticipates NSD will grant Legal Eagle's request for processing. Sure, NSD has not issued a final response as 20 working days has expired. We've exhausted our remedies, and we're in lawsuit land. LE repeats and realleges these allegations contained in this request. On the 18th of February 2020, LE submitted to OLC a DOJ-specific version of the request. LE requested expedited processing. OLC acknowledged the request. It granted the request for expedited processing and not adjudicate the fee waiver. LE submitted to OLC a DOJ-specific version of the request. As of this writing, it has not acknowledged it. Reasonably anticipates OLC will grant the request for expedited processing. It has not issued a final response. As 20 working days have elapsed, LE has exhausted all of his remedies, and we have a right to this information. LE repeats the allegations. On the 18th of February 2020, LE submitted to state, as in the State Department, a state-specific version of the request. LE's requested expedited processing of the request. On the 20th of February 2020, State acknowledged receipt of the request and assigned it a number. Denied the request for expedited processing. It did not adjudicate its request. LE submitted to State a state-specific version. As of this date, has not acknowledged. Reasonably anticipates it will deny the request for expedited processing. Yeah, I'm not sure on what basis LE over here is anticipating some to be yes and some to be no. I'm not sure why he's anticipating those things, but okay, he's anticipating those things. 20 working days have elapsed. We have a legal right to the information. LE repeats these allegations. LE has demonstrated there's urgent need of requester primarily engaged in the information to inform the public. The State Department has denied the request and has a legal right to these information. LE repeats the allegations. On the 18th of February 2020, LE submits to ODNI an ODNI specific version of the request. That's the Office of the Director of National Intelligence, by the way, in case you forgot that acronym, ODNI. LE requested expedited processing of this request. On the 28th of May 2020, ODNI acknowledged request and assigned it a number, denied the request for expedited processing, and granted a request for fee waiver. ODNI has not issued a final response to this writing. 20 working days have elapsed. LE repeats the allegations. LE demonstrated there's an urgent need. ODNI has denied the request for expedited processing. LE has a legal right under FOIA. LE repeats and realleges the allegations contained in the contained above. On the 3rd of March 2020, LE submitted to RAMSID a FOIA request for all current regulations, policy statements, guidelines, memorandums, training materials, handbooks, manuals, checklists, worksheets, instructions, and similar documents which provide direction for officials performing pre-publication review of documents submitted to your office. LE requested extensive processing of the request and public interest fee waiver, citing extensive public interest in pre-publication review process in general and as applied to the book. LE has also stated, in anticipation of a potential argument about this, we covered this earlier, the NSC as a whole is not an agency, however, the Access Management Directorate is an agency. We covered that. I am legally dubious. Then the Ramstead says, we are not an agency, which seems legally more promising. We have a right to this information. LE repeats and realleges the allegations. LE has demonstrated there's an urgent need of a requester to engage in disseminating by refusing to process. Ramstead necessarily denied its request. LE has a legal right under FOIA. LE repeats the allegations. On the 18th of February 2020, LE submitted to GWB Library a FOIA request for all regulations, policy statements, guidelines, memorandum, blah, blah, blah. LE requested expedited processing. Legal Eagle further explained, while these guidance documents will obviously not be about the book and may not even be current, they're still related to the topic of widespread media interest, since little is known about the pre-publication review process used by the NSC, and the rules used by the GW Bush administration are the most recent documents accessible by the public. So that's interesting. So we're trying to get access to the rules that exist in the archives for previous administrations. Not a bad idea. Not a bad idea. So we want to get them from the GWB library. Now, querying why we can't get them from Obama's records, but we want to get them from GWB's records for some reason. On the 20th of February 2020, the GWB library acknowledged receipt of this request. The GWB library denied Legal Eagle its request. The GWB has not issued a final response. As 20 working days have elapsed, we're entitled to this information, blah. Legal Eagle repeats the allegations. Legal Eagle demonstrated that there was an urgent need of requester to engage in this. The GWB library denied Legal Eagle's request. Legal Eagle submitted an appeal to the National Archives. LE submits an appeal to NARA, stating we succinctly demonstrated that knowledge about how the G.W. Bush White House handled pre-publication review would still be significant to the public when discussing the treatment of Ambassador Bolton's book, since it's likely to be substantially similar to the current process, where almost nothing is known outside the White House. This easily satisfies the test for expedited processing, given the widespread media interest. The archives acknowledged receipt of this, and LE has a right to the book. The 19th cause of action. LE repeats and realleges. On the 18th of 2020, LE submitted to LLC a FOIA request for OLC's opinions. LE requested expedited processing. OLC acknowledged receipt and assigned it a control number. Requested expedited processing and did not adjudicate its request. Legal Eagle submits to OLC a FOIA request for all the records which were created. As of this writing, OLC has not acknowledged this second request. LE reasonably anticipates that LE will be granted this request. OLC has not finished its response, and 20 working days have elapsed. The 20th cause of action. LE repeats and realleges the allegations contained in all the paragraphs set forth above. In the 26th of May, 2020, LE submits to state a FOIA request for the completed request for expeditious processing worksheet, fee favor worksheet, and FOIA PA request checklist for the request. LE added, if these forms have been superseded by other forms, please consider this to be a request for these newer forms. State acknowledged the request and assigned it a control number. State has not issued a final response. As 20 working days have elapsed, LE has exhausted his responses. Therefore, we have a legal right. So finally, we get to the prayer for relief. So 20 causes of action. Later, we get to the prayer for relief. Wherefore, plaintiff LE, LLC, prays that this court order the NRC, CIA, DOD, DOJ, DOS, NARA, and ODNI to release all the records. Order defendants to expeditiously process the request for which LE requested processing. Order preliminary injunctive for declaratory relief. Award attorney's costs. Expedite this action in every way. Expedite this action in every way. Wow. Every way. All the ways. Pursuant to law, and grant this as other relief may be. Signed this day, literally today, June the 25th, by Kellen B. Kellen B. McClanian, national security counselors for the plaintiff. So that is the lawsuit. Okay, so now let's talk a little bit about let's talk a little bit about all the things that the government is going to use, among other things, to not give this information. So if I'm the government, so I'll pretend I'm the government now. Okay. So if I were the government, first I'm going to argue that this entity within NSC is not an agency within the meaning of the law, because that seems pretty tenable. So they don't have to give you anything at all. So no, just no to any of that. So we are not. The White House is not subject. The president is not subject to to FOIA. The NSC is not subject to FOIA, and this director of this subgroup within the NSC is not within FOIA either. So that's one. And then as to everyone else, I'm going to use one of these many exceptions that apply. So for those of you who want to follow along at home, we are now going to talk about 5 USC 552, which is the Freedom of Information Act. It is an act that actually exists and has a number. It's 5 USC 552, if you want to look it up and play along at home. And it's fairly long because it contains all kinds of rules on how to submit them and timeframes and how they're processed and blah, blah, blah. But we are going to talk about the exceptions right now. We're going to talk about the things that the government doesn't have to give you. So these are the things the government doesn't have to give you. And here's the things that they're going to redact the hell out of all this stuff. So here's where they're going to fight you every step of the way. So the FOIA does not apply to matters that are specifically authorized under criteria established by the executive order to be kept secret in the interest of national security or foreign policy, and are in fact properly classified. So anything that was classified, anything that is in fact classified, we don't have to tell you about. Relates solely to internal policy rules and practices of an agency. So internal guidelines, internal memorandum, internal things that govern how the agency works internally, internal personnel rules, how we govern our employees, we don't have to tell you about that. Specifically exempted from disclosure by statute, if that statute requires that the matter be withheld from the public in such manner as to leave no discretion, or establishes a particular criteria for withholding first material to be held. So if there's a statute that says we can't give it to you. Trade secrets, commercial or financial information obtained from a person and privileged or confidential. Potentially, some information might be under this exemption if we had information relating to the contracts, that Bolton signed, which we probably did. Personal information of that nature. Trade secrets, internal review processes of the book publishers we don't have to tell you about. Interagency or intra-agency memorandums or letters that would not be available by law to a party other than the agency in litigation, provided the deliberative process shall not apply to records created 24 more or years before the date requested. So any of these letters that go back and forth between the sister agencies, probably we don't have to tell you about. Personnel and medical files, which would constitute unwarranted invasion of privacy, potential. Records or information compiled for law enforcement purposes, but only to the extent the production of records could be reasonably expected to interfere with enforcement proceedings, would deprive a person of fair trial, could reasonably be expected to constitute unwarranted invasion, could reasonably be expected to disclose the identifying source, or information compiled by criminal law enforcement in the course of a criminal agency investigation or agency conducting lawful national security investigation. Some of these may very well trigger for Bolton, I would imagine. Would disclose techniques and procedures, or could reasonably be expected to engage in danger of life. So yeah, anything that we did for law enforcement purposes. And now that Bolton is potentially looking at some criminal charges, because he has some criminal exposure, it seems to me, a lot of this stuff might come into play. Contained in or related to examination, operation, or condition reports prepared by the agency solely for the agency responsible for supervision of financial institutions, so financial information we don't have to give you, and also geological and geophysical information, including maps concerning wells. So we don't have to tell you where wells are. So yeah, that's good news. So, you know, all the classified stuff, 1A. Stuff relating to internal 1B or 2B, B2 comes up a lot. So internal practices, exemption from disclosure, yeah, interagency memorandums. So a lot of this stuff seems like it's going to apply. So a lot of this stuff is going to be lawfully redacted out. So that is good stuff. So, yeah. Now it is the case. Now it is the case that they have to give a response within this time periods, but the government probably has cause to extend those time periods because of the current situation and the reduced staff and stuff like that. So, you know, they probably needed to extend those time frames, but yeah, so good times. Well, we will be following this lawsuit on an ongoing basis. So the 142 of you who are out there who have been watching the stream, if you'd be so kind as to give the stream a like, I'd appreciate it. For all those of you who really like this content, if you'd hit the join button for 99 cents a month, you too can join the channel and be an Uncivilian, and it will be appreciated. And for everyone else, I just hope that you enjoy this content and you continue to watch my stuff. We'll be back later today with our regular released story, probably. So you can look forward to that. And until later, my friends, I hope you're well. Cheers and goodbye.